said, I'm representing the Honorable Attorney General and Minister for Justice. I'm the Executive Director of the Law Reform Commission, so the speech is being read on her behalf. Your Lord, I can't see my Lord here. I was expecting to see him. So, members of the bar, members of the media, law students, distinguished ladies and gentlemen. Since development is a conscious effort to transform society, law, as we all know, has a multiple relationship to this process. Laws must work, since laws shape society. Laws that do not work delay or distort development efforts. It follows, therefore, that law and legal processes must adapt to changing socio-economic processes. I would first of all like to share with you some of the linkages between law and policy on issues coming up for discussion. The first issue is whether government engages in research and whether it utilizes the findings of research as a guide in considering what changes need to be made to existing policies or the development of new policies. Laws that work must be grounded in research. Researches on diverse subjects using different approaches are necessary if legal scholarship must enhance our understanding of the problems of development. Through this process, policy making is made more effective and clear-cut rules are provided to persons engaged in implementation rules. Research is designed to aid policy. As a result, institutions which link researchers to policymakers in a systematic way are necessary tools for development. The Law Reform Commission, which engages in legal research, and the drafting section of the Ministry of Justice, which drafts appropriate legislation, are examples of such government institution. The other issue we saw was laws that work, the reform process. Making new laws and policies is usually a very slow process involving a number of stages through which key issues are debated and negotiated. There is a methodology of the law reform process which is grounded on two main areas of focus: development and a participatory approach. Thorough research is done with the full use of experts, widespread and serious consultation, complete impartiality, and comprehensive analysis of laws in other jurisdictions. Stakeholders are selected from the judiciary, civil society organizations, the media, academia, the legal profession, and ordinary citizens. Issue papers, consultative documents, working papers, etc. are circulated. Seminars and workshops are also conducted before a report is drawn up and submitted to my ministry. The report is then forwarded to Cabinet, and then the appropriate ministry which oversees the policy implication of the law leads the discussion of the issue in Parliament. Parliament always insists on stakeholder consultation as important criteria in the making of laws. It has specialized committee sessions and general discussions on the floor of Parliament. Parliamentarians then take the final decision on whether the draft law should be passed with or without amendments or not at all. Laws that work, non-state actors. Another issue coming up for discussion is whether government takes into consideration the findings and reports of other non-state institutions. I say, why not? We are in a democracy. A number of laws currently operating in the country, especially laws dealing with human rights issues, gender-based violence, land reform, repeal of the criminal libel law, review of mining laws, etc., have been enacted based partially or fully on recommendations from non-governmental agencies, individuals, etc. The other issue is how public policy has affected our laws. Policy processes must not be remote from the problems laws are designed to solve. Laws must not also be cut and paste solutions designed for elsewhere, but thoroughly grounded in local issues. Any legal system to be effective must encourage the engagement of its citizens and reinforce the strength of its law enforcement agencies. After all, justice has to be delivered on the values of the society that it intends to protect. Public policy on a number of issues have affected or led to the reform of laws on women's rights, property rights, intestate succession, children's rights, trafficking of persons, banking laws, monetary policies, and the rule of law and justice generally. The directives of state policy. The directive principles of state policy in Article 34(1) of the 1992 Constitution is to serve as a guide to all citizens, Parliament, the President, the Judiciary, the Council of State, Cabinet, political parties, and other bodies and persons in applying or interpreting this Constitution or any other law, and in taking and implementing any policy decisions for the establishment of a just and free society. Under the directive principles, we have political, economic, social, educational, and cultural objectives. As a country, we are also to promote respect for international treaty obligations by the domestic application of laws that Ghana as a country has acceded to. Policy dynamics before and during implementation are also guided by current national goals, national development plans, the Ghana Shared Growth and Development Agenda, sector medium-term development plans, etc., under a broad thematic area of transparent and accountable governance. To conclude, I congratulate the Noble Law Group on the choice of topics and resource persons. The continued promotion of intersectoral cooperation and collaboration of policy-shaping institutions in the governance system is a laudable one. I wish you successful deliberations. Thank you.